just war theory, that account of just cause and jus ad bellum more generally was extremely state-centric. It focused, at least in its post-Westphalian mode, almost exclusively on the rights and responsibilities of states. So we had a conception of the state that was very much built around what, again, Michael Walzer described famously as the domestic analogy, the idea that we could think about states as having a set of rights and responsibilities that were in many ways like the rights and responsibilities of individuals, written large, expanded up onto the level of the corporate actor of the state. So just as the individual person has the right to life, the right to bodily integrity, so the state has certain rights, most notably the right to political sovereignty and the right to territorial integrity. Just as an individual person, if he's subject to unjust aggression, can have the right to kill in self-defense, so the state, when its rights to political sovereignty and territorial integrity, if they were unjustly impinged or attacked, it would have the right to kill in the course of a defensive war. But I think what complicates significantly and problematizes that picture is the fact, the very obvious fact, that states are not only unitary actors, they are actors that are made up of a large number of individual persons who are themselves the bearers of rights and obligations. So when we think about war, when we think about just cause and the justification of war, we always have to bear in mind this duality, the duality of the corporate level of the state and of the individual. We have to think very carefully about the interplay between the individual and the state. And what I think in practice that this means is that when we pose the question of when we pose the question of war in terms of liability to harm, liability to attack, which is the way that I was suggesting we pose it in the panel this morning, we need to think about that question both from the perspective of the state and from the perspective of the individual. And it's important to realize that we can have liability at either of those levels without having it at the other level. So we can have a case where individuals within another state may be liable to harm or attack, say, for example, because they're committing a crime, right? They're committing a crime of assault or aggression against other individuals within that state. So we might say those individuals are liable to be harmed and attacked, either in self-defense or punitively. But we might say that there's no right to intervene because it's another state, it's another polity that has its own political sovereignty. And the harmful action against those individuals would be improper political interference. So that would be a case where there's individual liability without state liability. It might be other cases where a state has engaged in certain kinds of wrongful action that makes us say, well, that state oughtn't to enjoy the rights of political sovereignty. But nonetheless, we might say that individual soldiers within that state's army have not done anything to make themselves liable to attack. So the case that we were talking about this morning, where we might say that there was a conspiracy at the level of the political elite of a certain state to engage in an act of aggression, but no unjust action by the soldiers, might be a case like that, right? You might say, well, the state doesn't have a right against intervention, but nonetheless, if we killed the soldiers, we would be wronging them. So this is to suggest that when we're thinking about these very basic issues of ad bellum justice and thinking about just cause, we have to constantly bear in mind these two levels of justification, the level of the state and the level of the individual. And I wrote a book a number of years ago that, if those of you who are interested in it may want to kind of follow these arguments up, to say that when we think about central just causes, even the most central just cause, which is the cause of self-defense against foreign aggression, it's extremely difficult to give an explanation for why we should have the traditional package of rights and responsibilities that we have traditionally taken states and armies to have within just war theory. I argued there that you can look at this question either in terms of what I call the reductive strategy. You could say, well, let's look at whether we can give an account of national self-defense as simply a complex exercise of fundamentally individual rights, right? So to say national self-defense is nothing but rights of individual self-defense exercised in a collective way. alternative way that you could look at it is to what I call the analogical strategy. You could say, well, let's look at states genuinely as being rights bearers analogous to individuals and see whether we can give an account of national self-defense that way. And I argued that in both of those contexts, it's very, very difficult to give a picture of a just cause of national self-defense that will give you something that we can recognize as a package of military rights that we find within traditional just war theory. Now, I think the reason why we have these problems, it seems to me, it's pretty clear, has to do with the rise of the doctrine of individual human rights. And Michael Walzer spoke about that in his lunchtime keynote address. I mean, it seems to me that the rise and universalization of the doctrine of basic human rights in the 60 years or so after the Second World War has been one of the most significant and profound developments in our collective normative experience. It's been an absolute transformation in the way that we think about ethics, and the impact on just war theory and our thinking about the use of military force, I think, is still very, very much in its infancy. But it seems clear to me that this idea, the idea that all humans everywhere have a certain package of basic rights, certain things that ought never to be done to them, unless they have themselves done something to make them liable to that, is going to have an absolutely profound and transformative effect on the way that we think about everything in just war theory, and in particular on just cause. So let me just identify what I think are going to be 4 of those very significant effects. One of them, obviously, has been to create a space for ideas about humanitarian intervention and the doctrine of responsibility to protect. If the idea of individual human rights plays this kind of foundational role that we seem to increasingly be accepting that it does, then it's clear that that opens up a space for action against sovereign entities on the basis of protection of human rights. And we're seeing that idea, although very imperfectly and very messily worked out, we're seeing that develop very, very clearly, I think, in terms of the rule of responsibility to protect, and also the way that just war theorists have dealt with these issues within just war theory. A second set of implications is something that Jeff McMahan has done an enormous amount of work on in the last decade, and I'm sure he probably will say a few words about it here today, which has been to problematize the idea, the traditional just war idea of the moral equality of combatants. Right? If we agree that basic human rights, and in particular the right to life, is a basic constraint on all action, not only in the domestic context but also in the military context, then it's very difficult to see how the traditional idea of a symmetrical and equal combatant right to kill enemy combatants can be sustained. It looks like you're going to have to draw some kind of distinction between those combatants who are liable to be killed because presumptively they're fighting in an unjust war, and those who are not. Another one, I think, is the implication that I spoke about this morning, although here I think that the consequences of thinking about human rights are much more in accordance with traditional interpretations of just war theory. And that is in the question of whether we consider preemptive or preventive military action to be appropriate. I suggested this morning that if we take seriously the idea of human rights, and that that military action can only be justifiable if it's directed against those that are liable, then that makes it very difficult to understand how preventive action, or action against soldiers who are not yet engaged in wrongful aggression but you think might be about to do so at some point in the future, it's very difficult to understand how that can be morally appropriate. Well, as I said, that is, I think, a conclusion that's much more in accordance with traditional just war principles. And the final one, I think, is the one that Professor Walzer was addressing in his lunchtime address. It seems to me that if we take seriously the idea of human rights as a constraint on military action, then it will inevitably imply that our thinking on issues like necessity and proportionality will have to be much, much more restrictive than I think we have tended to interpret those in just war thinking in the past. And I think that we can see that if you think about what we would consider to be appropriate risks and costs for civilians in an anti-terrorist action that was undertaken on our own territory, where it was our own citizens who were exposed to that collateral harm. If you think about the way that we would think about appropriate rules of engagement, appropriate risk to civilians in comparison with the way that we think about appropriate risks and harms for an action undertaken in Iraq or Afghanistan, for example. If you think about the gulf in the different ways that we think about everything from the way that we equip, think about ROE, the level of risks, there's an enormous gulf there. And it's very, very difficult to explain how that gulf can be understandable if we start from the assumption that humans everywhere have the same package of rights. So I think that this kind of broad realization, this tendency of arguments that I think have originated from this profound and seminal idea that's been in the process of working out for the last 65 or so years, this idea of basic human rights, is going to transform an enormous amount in just war theory. And it's, I think, going to have effects that are normally much, much more restrictive and constraining than we have tended to think in the past. And I just want to finish with the thought, although very schematic, but the thought that it's conceivable to me that the ultimate ending point of this series of arguments, of this kind of working through of this idea, may be to question the very purpose of having an independent category of jus ad bellum with its central idea of just cause. It seems to me, one of the questioners this morning, I think, put the idea quite well. He said, the way that we tend to think about just cause is we have a very high threshold for action, right? Very high burden for entering into that state of war, that state of collective political violence, because we understand that it has all of these awful moral effects, right? We understand that we're going to be killing intentionally or unintentionally people who oughtn't to be killed. So the idea is you have this very high threshold precisely because you recognize that there is a permission to do things within that context of war that would otherwise be utterly impermissible. But another way of dealing with these cases would be to develop a set of moral ideas that is much less discontinuous and much more a continuation of the way that we think about appropriate defensive action in the context, for example, of emergency policing. Right? So we might try to work on a conception of the ethics of law that is not radically discontinuous with the way that we think about protection, law enforcement, and defense in domestic contexts, but is, as it were, a continuation of that, and that tries to implement in a much more consistent way the way that we think about protection of civilians, risks, harm, and so forth in those domestic contexts, extended with appropriate modifications to these international contexts as well. So I think I'll leave it there and we can pick up the discussion.
Thank you very much. Our next speaker, as Professor Rodin mentioned, has been doing some incredible work on just war theory over at least the past decade or so, almost like untangling certain things that have been assumed by others and really sort of subjecting it to some incredible philosophical rigor. I know personally I've benefited a great deal from his work. I'm talking about Jeff McMahan, professor of philosophy at Rutgers, author of The Ethics of Killing, Problems at the Margins of Life, and Killing in War, both published by Oxford. Apparently he has several books forthcoming from Oxford. This seems unfair, by the way, including The Right Way to Fight and The Value of Lives. So please join me in welcoming Professor Jeff McMahan.
Thank you. Perhaps I should follow the example of an earlier speaker and say that the views that I'm going to articulate don't represent those of the U.S. government or the Navy or the Army. I think, more is the pity, but still.
Or Rutgers University.
Or Rutgers University, for that matter. Yeah, I'm on my own in this. A moral justification for going to war, I think, has to address what's morally most problematic about war, namely that it necessarily involves killing and injuring people. My view is that violence in general, and killing people in particular, is just only when the victims have made themselves liable to be attacked or killed, or made themselves liable to the harms that we inflict on them through violence. This is basically registering agreement with the claims that David has been making. Now, they're liable to be harmed in a certain way when they've forfeited their right not to be harmed in that way, so that when our justification for harming somebody is that that person is liable to be harmed in this way, we're not wronging that person when we harm him in that way. People normally become liable to defensive harm, in my view, by being morally responsible for a threat of wrongful harm to others. Now, the reason why I use the word just here is that I'm talking about something more than mere permissibility. I'm actually talking about a justification that appeals to considerations of justice. Defensive harming, I think, is a specific area of justice, like retributive justice or corrective justice or commutative justice or whatever. It's a specific area of justice that's concerned with the ex ante distribution of unavoidable harms. And my view is that when possible, harms that are unavoidable should, as a matter of justice, go to those people who, through their own wrongful action, have made it inevitable that someone has got to be harmed. Now, in this understanding about the relation between justice and liability and so on, there's a just cause for war is an aim that may permissibly be pursued by means of war because those warred against have made themselves liable to be attacked militarily as a means of achieving some aim, usually a wrong for which those individuals are responsible. So in particular, there's a just cause for defensive war, on my view, when the people warred against are themselves morally responsible for a threat of wrongful harm that's sufficiently grave to make them liable to be killed or injured as a means of preventing that wrongful harm. Now, of course, war normally involves killing a lot of people. So for there to be a just cause for war, there have to be many people who are liable to be killed as a means of preventing the wrong for which they're responsible. Let me say a little bit more about that. If the goal of a war can't be achieved by intentionally making war only against people who are liable to be attacked, if it can be achieved only by making war against people who have not made themselves liable to attack, that is, if it involves attacking people who are innocent in what I take to be the relevant sins here, then the goal that one is pursuing by means of war can't be a just cause for war, as I understand that notion. The goal may be a good goal. It may even be a just goal. It might be a goal that can justifiably be pursued by means that involve the infliction of lesser harms than are inflicted through war. So it might be a just cause for various other kinds of action. But if the people aren't liable to be militarily attacked and killed, then you don't have a just cause for war, as I'm understanding the notion of just cause here. So, on my view, there can be a just cause for war only if there are enough people who are liable to be killed or injured to make the use of military means potentially proportionate in relation to the liability of those people who are attacked. If the wrong one is threatened with is insufficiently serious, then those who threaten it may not be liable to be killed, though they may be liable to lesser forms of harmful action. Now, here's an example. It's not meant to be actually a focus on the actual case. Let's just take a case of a war that was arguably disproportionate in this kind of special sense that I have in mind here, the Falklands War. there were 1,800 inhabitants of the Falklands Islands. That was roughly the number of Argentine casualties caused by Britain's war. Imagine, though, that the war, in order to have preserved British sovereignty over the Falklands Islands, would have required the killing of 100,000 Argentine combatants. Just making this up, of course. I would want to claim that protecting the independence of the way of life of the 1,800 Falklands Islanders would not have been sufficient to make 100,000 Argentine combatants liable to be killed. So if that war had required killing that many combatants on the other side, I'm not talking about, killing innocent people as a side effect here. I'm actually talking about killing people who would be fighting for unjust aims. I think there wouldn't have been a just cause for war in that case, though there would have been a just cause. That is, I think Britain had a just cause for some kind of action there. So what I'm suggesting here, though, is that just cause and liability and a certain notion of proportionality are conceptually interrelated. Now, this leads to some problems that I'll mention in a minute, but let me also note here that the appeal to the claim that one has a just cause for war, therefore that one's war can be just in that the people against whom one is fighting won't be wronged by the harms that one inflicts on them. In addition to that form of justification, there are other possible forms of justification for the resort to war. So I don't think that just wars in principle are the only types of war that can be permissibly fought. There's another kind of justification, which is a justification for harming people, which is the justification of necessity or lesser evil. This is a form of justification that we have to appeal to when we are harming people who are innocent, that is, people who are not liable to be attacked. And this happens in war. So the form of justification here is a very familiar one. Whenever there really is a moral justification for killing or injuring innocent bystanders as a side effect of military action in war, that justification is going to be a lesser evil or necessity justification. It's not going to appeal to any claims about liability on the part of the victims. We acknowledge we're going to be wronging them. We're going to be infringing their rights. But sometimes we concede that that can be permissible unless we are absolutists. What this means is that, in principle, there could be a war that it would be morally permissible to fight. It could be a justified war, though it wouldn't be a just war. It wouldn't have a just cause. We would be wronging the people we would be fighting against. The only historical example that I can think of that approximates that kind of case is the Winter War between the Soviet Union and Finland. This was I don't want to say that I think that the Soviet Union's war actually was a justified war. I'm just suggesting that this is a near case. Anyway, the Soviet Union wanted to borrow a bit of Finnish territory for the defense of Leningrad against the Nazis, and the Finns refused. The Soviet Union offered an exchange of territory so that the Finns would get more Soviet territory than the Soviets would take of Finnish territory, and the Finns refused. Suppose we think that the Finns were permitted to refuse. I think they probably were. Suppose we then thought also that the Soviet Union had grounds of necessity or lesser evil. They were thinking that by fighting on Finnish territory, they might be able to save the lives of millions of innocent people in Leningrad from Nazi attack. If we change some of the facts of the case, we might have an example there where the Finns were justified in resisting, the Soviets were justified in attacking, but they certainly didn't have a just cause. There was nothing, in my sense, of just cause. There's nothing that the Finns had done to make them liable to be attacked and killed by the Soviet Union. Now, there's a general problem about national defense that's raised by this understanding of just cause that I'm presenting to you today was developed extensively in David's book, War and Self-Defense, which is raised by the example that I gave a moment ago of the Falklands War. What happens when an unjust aggressor threatens only lesser values? Nobody had any thought that the Argentine military was going to kill anybody on the Falklands Islands. There was really initially only a threat to the sovereignty of those islands. Who was going to be the sovereign over the 1,800 people on the islands, the British or Argentina? Now, of course, once Britain decided to defend the islands by military means, then the Argentine forces posed a different kind of threat. But initially, they may have posed only a threat to this British sovereignty over the Falklands Islands. And actually, what's surprising, if you think about it, is that a lot of wars look like that initially. That is, you're familiar with the idea that aggressors claim to love peace. And of course, there's a sense in which that's true. They'd much rather get what they want without having to go to war. So they would like to get what they want by peaceful means. That is, you just submit to them and give them what they want. Very often, what aggressors want are things like natural resources, a bit of territory, some political control over other people's affairs, that kind of thing. But they don't necessarily want to kill anybody or harm anybody physically or perpetrate violence against anybody. They would happily not hurt anybody if you just give them what they want. There is then this question of how you can justify killing large numbers of people, particularly when these people are usually young people who are fighting under duress and in conditions of epistemic limitation, they don't know all the facts and so on. How it can be justifiable to kill a very large number of these people in order to defend these lesser values or lesser rights, rights of territorial integrity, political independence, rights over natural resources, and so on. I'm not going to actually pursue that question. I think there's a lot that can be said in defense of war, in defense against this kind of lesser aggression that's backed by a conditional threat to kill people if you engage in resistance. I actually think there's a lot that can be said there, but I'm not going to say it today. The reason I bring it up is just to flag a problem that arises for those of us who accept the kind of conception of just war and just cause for war for which David and I have presented a case today. For David, this problem pushes him closer towards a contingent form of pacifism. For me, I dig in my heels and try to find good arguments for resistance. But I'm not going to try to give you those today. What Ed Barrett asked me to focus on today was something that David mentioned briefly in his talk, and that is that the view of just cause that I've just sketched, I think really entails a radical revision of the in bello morality of war. It entails the idea that there's an asymmetry in war between those who fight on behalf of a just cause and those who fight without a just cause. Because what we're asking here about in bello morality is what justifies soldiers in fighting against, killing, and injuring soldiers on the other side, and also killing and injuring innocent bystanders as a side effect of their military action. Now, if the justification is that the people against whom one is fighting have, through wrongdoing, made themselves liable to attack, that justification is going to apply only to the action of those who are fighting in support of a just cause, not for those who are fighting without a just cause or on behalf of or in support of aims that are actually unjust or wrongful. What this means, I think, is that if you take the traditional requirements of jus in bello seriously and you understand them in their generic form as I think they need to be properly understood, you'll see that people who fight in the absence of a just cause actually are not acting morally permissibly. Take, for example, the requirement of discrimination. In its generic form, what it says is not discriminate between combatants and non-combatants. What it says is discriminate between legitimate and illegitimate targets of attack. As I understand those notions, a legitimate target is someone who's made himself liable to attack, someone who no longer has a right not to be attacked. Well, I think, as I think David said earlier, that someone who fights justifiably in individual self-defense and defense of other innocent people against wrongful aggression isn't doing anything that causes him to forfeit his right not to be attacked. He's not a legitimate target for attack in war. Therefore, the requirement of discrimination, as I understand it, implies that it's wrong to attack such a person. So people who are fighting without a just cause against people who do have a just cause can't be acting in accordance with the requirement of discrimination. I think a similar claim applies to any kind of sensible understanding of the in bello requirement of proportionality. I defy you. I have 4 minutes, not 3. I'm going by my watch here. I just used a minute of my
Now you have three.
But I'm not granting you any more.
Okay. The problem here is easier to understand, perhaps, and that is proportionality requires you to take account of the anticipated good effects of your action and the anticipated bad effects. We have a good idea of what the anticipated bad effects are. Let's just focus for the moment on harms unintentionally caused to innocent bystanders, something that happens very often in war. How can one justify those if one is fighting in a war that lacks a just cause? What is the good against which those harms can be weighed to determine whether the harms, whether the bad effects are actually proportionate? What are they going to be proportionate in relation to? Well, a couple of people earlier today have said that they are to be proportionate in relation to military advantage. That's what it says in Geneva Protocol 1. But military advantage in itself is neither good nor bad. It's bad when it goes to the Nazis. It's good when it goes to the Allies. When military advantage serves unjust ends, it can't coherently be weighed against harms to innocent people to see whether it outweighs them or balances them out. Therefore, it seems to me, people who fight in the absence of a just cause also can't satisfy a plausible requirement of in bello proportionality. I think that if you are attracted to this approach to the understanding of the morality of war that David has outlined and I've tried to sketch with respect to just cause, you end up with a very different picture of the morality of war. It's one in which there's a deep moral asymmetry between those who fight in just wars and those who fight in unjust wars. This leads to a lot of other questions. Questions that I think are central within traditional just war theory. They're posed there as questions about the morality of war. I think these questions all are important, and they do arise, but I think that they're actually more questions about law. That is, they're questions, how can we actually, in practice, constrain the action of people who are fighting in unjust wars and in all probability don't know that they're fighting in a war that's unjust. We need to be able to say things to them other than just go home, everything you do is impermissible. So what I've said today just sets up a problem. It doesn't give the answers to the really important practical issues, but I think there are answers. Thank you.
Thank you. I think if you look at the roster of speakers, you can see that this is really an unprecedented two-day conference. I mean, it's just an amazing group of people. But I think, and I might be wrong about this, also unprecedented is that we have on the same panel two professors from New Jersey's greatest academic institution who are finally given an opportunity to engage each other's thought. Like Professor McMahan, James Johnson teaches at Rutgers University. He is the professor of religion and associate member of the Graduate Department of Political Science. He has been on the faculty since 1969. His research and teaching have focused principally on the historical development and application of moral traditions related to war, peace, and the practice of statecraft. He's received Rockefeller, Guggenheim, and National Endowment of the Humanities fellowships, along with other research grants. He's directed 2 NEH summer seminars for college teachers, and he's written many, many essays and many books on war, like I said, that are enormously influential in theology, in Christian ethics, and outside of those disciplines. I'm just going to name a couple of those books. Ideology, Reason, and the Limitation of War from Princeton University. Can Modern War Be Just? In 1984 from Yale. The Holy War Idea in Western and Islamic Traditions, 1997, and Morality and Contemporary Warfare from Yale in 1999. So please join me in recognizing and welcoming Professor James Johnson.
Thanks, Joe. I'm not sure whether Jeff McMahan and I are going to engage each other or not, because actually our approaches are so different that we tend to pass each other in the night in terms of the sorts of topics we treat. But this gives me a chance to alert you that what you're going to be hearing from me represents a rather different approach to the whole idea of just war, its meaning, and what ought to be understood as important in it. Because I begin with the historical tradition, and I have increasingly, in recent years anyway, sought to work more specifically from what I call the classic understanding of that, which is the understanding that took shape in the period from the middle of the 12th century to the middle of the 13th, and is summarized very effectively by Thomas Aquinas in his Question on War. The issue that is before us then is what to do with this set of ideas. And I would suggest that it's appropriate in certain ways to approach them in terms of the kinds of concerns you've heard from the previous speakers. But there is also something very important, if we're going to call this just war reasoning, in looking back at what this tradition was originally conceived to be, what it was about, what its purpose was about, how it was interpreted by people in the time, and how it was applied there. Then draw implications from that. Through most of the history of just war tradition, writers on just war, when listing the requirements for just resort to armed force, followed the example of the consensus reached by the canonical writers of the late 12th and early 13th centuries and summarized by Aquinas. First, not just cause, but the authority of a sovereign ruler. Second, just cause, and defined as retaking that which has been wrongly taken and punishing evil doing. And then third, right intention, defined negatively as the avoidance of intentions grounded in personal vice, and positively in terms of aiming to secure peace. This was a conception of the justification for resort to war, which was of a piece with the broader understanding of political good as defined in terms of three distinctive goods: order corresponding to sovereign authority, justice corresponding to just cause, and peace corresponding to right intention and the end of peace. It strikes me often when I'm reading contemporary writers on just war that it would be great if we had a general conception of politics within which this moral discussion is placed, because that is of extreme importance in the historical tradition, and it seems to me to be important in contemporary condition as well. At any rate, in this classic tradition, the primary necessity for a just war is sovereign authority. The other necessities named follow not only in precedence, but also they depend on that authority. For among the responsibilities included in those of sovereignty are determining when there is a just cause for a resort to armed force on behalf of the political community, and ensuring that the intention in the use of force is maintained and is focused on the purpose of creating or reestablishing a disordered peace. So there's a marked contrast between this conception and the majority of present-day just war thought. Present-day discussions of the idea of just war commonly give priority to the question of just cause in the listings of requirements for justified resort to force, while at the same time giving less weight to the matter of authority or discounting it altogether, thereby leaving open the whole question, well, who decides who has just cause? This was very clear in the classic understanding. It was the responsibility of the sovereign, because the sovereign had responsibility for the common good of the political community. And so this was really what that was all about. It was helping the sovereign to decide when, given these responsibilities, there was a justification for use of armed force. Armed force was not itself an evil. Armed force was one of the tools in the tool basket of statecraft. If we carry this downward a step, we move from the sovereign in the political community to the military commander and ultimately to the individual soldier. Each of these has analogous, although not the same, responsibilities. Each one has different responsibilities towards the people who are immediately in his charge as compared to people that are not. There are general responsibilities, to be sure, to the overall moral order, but there are immediate responsibilities to those in the sovereign's political community for the sovereign, those in one's command for commanders, and one's fellows in one's own unit if one's an individual soldier. And this allows me to suggest that perhaps the idea of the moral equality of soldiers needs to be thought of somewhat differently when we approach the matter of just war in this way. The moral responsibility that I have to those in my charge means that there is a fundamental way in which they are not the equals of even the non-combatants among the enemies, and certainly the enemy soldiers. At any rate, this is too long a paper for me to read it all, and so I won't read it. I have a long section in here about the history of this, how we got to the present day way of thinking about all of this, and particularly the matter of just cause. Broadly speaking, the big change comes at the beginning of the modern period, and I always trace it to Hugo Grotius intellectually and to the Peace of Westphalia in institutional terms. Here the idea of sovereignty shifts. After Grotius and Westphalia, you don't have any longer a conception of sovereignty in moral terms. It has become defined territorially in terms of the territory of a particular society. It's the people that are in it and the laws and privileges of those people in that society. But the idea of the ruler of that political community having a kind of moral responsibility that extends to helping him to him or her or them to determine when it is justified to use armed force, that gets lost beginning with Grotius. And it finally reaches the kind of heyday, I think, when we come to the sorts of situations that lie behind the creation of the International Commission on State Sovereignty and their report, Responsibility to Protect, because the end result of the Grotian-Westphalian conception was that somebody who is the ruler within the framework of the sovereign territory can do anything he damn well pleases there, and it's nobody else's business. And that is just wrong, you see. So we lost something in moving to that conception. Excuse me while I scroll forward here. This is supposed to be a session on just cause, and I've so far mainly been talking about sovereign authority. So now let me get to that part in this written text where I do talk specifically about just cause. Part of what the sovereign must do to discharge his responsibility for the common good is to judge which issues justify resort to armed force. That's why in classic just war reasoning, just cause comes after the requirement of sovereign authority. Classic just war language signals this explicitly in linking the determination of just cause and the authorization of force to the action of a judge. This is the terminology that is actually used by the canonists. The sovereign is a judge, and that means he has a responsibility to make a judgment in these matters. It's not really all that clear-cut in many cases. What, from this perspective, constitutes a just cause for a resort to armed force on behalf of the good of the community? Aquinas' summary statement, drawn from Augustine, identifies two such cases. It avenges wrong when a nation or state has to be punished for refusing to make amends for the wrongs inflicted by its subjects or to restore what has been seized unjustly, and thus a just cause for use of armed force exists when there is an unanswered need for punishment and/or restitution. Now, anybody in the current environment would say, well, what about self-defense? The permissibility of self-defense was simply assumed on this construal, but it is not a right of everyone to act on behalf of the political community in self-defense, and the political community has a further right, that is, the right of acting after the need for defense is over. The language that was used and that became normative was, it is permissible for anyone to wage war in self-defense or to protect property, nor is this properly called war, Latin bellum, but rather defense, Latin defensio, two different things. One may lawfully fight back on the spot, and the language, the Latin is incontinenti, before he has turned his attention to other matters. That is, private individuals and princes both have the right to use armed force in defense when the need is right there. But what about afterwards? Only then does the sovereign have a different kind of responsibility, that is, for setting right the disordering of justice and peace. And that's what classic just war tradition really addresses, the need for the setting right of these lost or damaged goods. When one begins to think about just cause for the use of armed force from the perspective of the highest political leadership and its responsibility for the public good, several considerations appear. The problem may not be the absence of justifying causes, but for resort to force, but in fact their multiplicity. There may be a lot of them, so that the problem of leadership becomes one of judging where to strike the balance. While persons in the highest political authority have their first responsibility to their own political community, they also clearly have a responsibility to what we might call the community of such communities, whose overall welfare is necessary for that of one's own community. Further, where the use of force is concerned, there are responsibilities toward the members of the community towards which that force is directed, but they're not the same as the responsibilities that one has towards one's own community. Universal conceptions of right bear on how each of these responsibilities is understood. But at the same time, the nature of political responsibility imposes a hierarchy on these various kinds of responsibility. On this, there is striking coincidence of a sort not often seen between political realism and the natural law conception of the hierarchy of preferences imposed by nature. The needs of one's community come first in consideration, and then there is a graded hierarchy following from that. With the implications of this perspective in mind, what are the various ways of framing the possibility of just cause for use of armed force typically found in the current debate? I don't want to talk about all of them, but I'll mention two in particular. The first is the idea that force is only justifiable in self-defense against armed attack. And secondly, I'll talk about the idea that the use of force is justifiable for humanitarian intervention. Historically, the defense requirement is a resort to force, is a justification for resort to force only in a backhanded way. The first aim of this, as it appears historically in both law and moral thought, is to prevent resort to force, not justify it. So if we look back at the Kellogg-Briand Pact of 1928, we find that the language of the treaty is about states renouncing the right to use armed force in settlement of disputes with one another, and it's only in Secretary of State Kellogg's private correspondence that we see that this isn't in fact intended to take away the traditional right of self-defense. Similarly, in Article 2 of the UN Charter, the language of the Kellogg-Briand Pact is picked up again, and it's not until Article 51 that we find the language that allows self-defense, individual and collective self-defense. And even then, exactly what is allowed remains subject to interpretation, and I would suggest that properly it needs to be. For example, Israel's preemptive attack in the '67 war, which Michael mentioned earlier, was denounced by the de Gaulle government as illegal because there had not yet been an armed attack. There was a spirited debate in this country, to change to another topic, during the high years of nuclear uncertainty between the U.S. and the USSR over a launch on warning policy, or whether instead to strike first or to reserve our nuclear response to a Soviet attack until the missiles had landed. This morning panel on preemption, as well as a number of recent books and the ongoing debate over the 2003 invasion of Iraq, show that this issue is still in debate and still important. This rather tangled history shows that the idea of defense as just cause is not as simple as many would claim it is at first blush. It's also problematic, defense is, because of how this conception has become stretched in contemporary usage to cover what are clearly other rationales for justified use of armed force. Deterrence, which is really retaliation and punishment, response to an armed attack in progress, the language that was used both to justify Britain's action in the Falklands and to justify the removal of Iraq from Kuwait after the invasion in 1990. In classic just war terms, these were recovery of what has been wrongly taken. In any case, it's restoration of justice. The upshot is that whether a state may rightly resort to armed force in a given context turns out to be finally a matter of responsible statecraft. And just war thinking historically had to do with this, but I suggest that a good deal of contemporary just war thinking, by ignoring the application of the reasoning to statecraft, punts and doesn't really deal with it. Well, I'm running out of time, so I won't talk about the issue of human rights. I do want to say a few words in conclusion about the issue of the use of force in responding to actions by non-state actors. Armed conflicts involving non-state actors have become the principal face of contemporary warfare. And the assumptions, this is in contrast to both the assumptions that guided the shaping of much of positive international law, and the assumptions on which a lot of contemporary just war thinking have focused, namely that modern war would be a kind of World War III involving nuclear holocaust. But the real problems with warfare focused on non-state actors are very different. Such actors are often very hard to get at. They often define their cause in such a way as to erase distinctions between combatants and non-combatants and engage in actions that directly target non-combatants as a preferred means of fighting. They don't wear distinctive marks, thanks to the 1977 Protocol 1, and they hide among civilians so as to do harm to those civilians, again, thanks to Protocol 1. Their command structure is dispersed so that responsibility for particular actions is difficult or impossible to trace, and so on. So the kinds of considerations that Michael Walzer was putting before us at lunch turn out to have some other ramifications also, because the playing field is not in fact level. The legal playing field is not in fact level between regular militaries and non-state actors, but not level in the way that other people would probably say, level in a different way from what others would say. This kind of fighting is in direct challenge to both the provisions of international law and conclusions of just war reasoning. Moreover, responding effectively to it may involve one's own armed forces in kinds of action seriously in tension with both or in direct contradiction. And again, the matter of the not having a level playing field. Members of regular national armed forces are, because of the way such forces are structured, the records kept and so on, able to be held to a stricter standard of behavior than the people they're fighting against, who, because of the structure of their bodies, are able to dodge being held responsible. I will just conclude by noting that for centuries, just war tradition maintained a strong bias against the kind of irregular non-state fighting groups that we find in contemporary asymmetric warfare. Their leaders were, in first place, understood as not having the right to authorize the use of armed force, and so by definition they were fighting unjustly. Accordingly, their taking arms meant that there was no distinction between them and criminal bands, for both operated outside the law. Second, their means of fighting, even in the pre-modern era, tended to increase the level of death and destruction in war because of the weapons they used, the fact that no quarter was given and no prisoners taken in such war, and the larger number of people that might take arms in popular uprisings. And so I suggest that these issues also need to be taken account of or at least need to be subject to reflection in taking account of whether there is a justifying cause in dealing with attacks from such groups. Thank you.
Thank you all very, very much. We have good time for questions. I am going to assert moderator privilege and begin those and ask two of my own. I think they're pretty small or quick ones, and they're both to Professor McMahan and perhaps Professor Rodin as well. The first one, I think, again, is a quick one, and they're both for clarification, just to try to understand what you're saying about just cause. Are there any other possible justifying reasons why somebody might kill somebody other than a physical threat being posed? So, for instance, like the threat of like cultural eradication. So, like think of China and Tibet. Like, okay, they're not in there necessarily going to kill the Tibetans, but they're going to occupy the country and educate them out of Tibetan culture, et cetera, arguably, right? Would that be the kind of thing that perhaps could be a just cause? The second question, and I think it's slightly related, but you don't have to try to relate them, goes to the second justification, which was the justification by necessity, and you use the language or distinction between justified and just, right? So you said, and if I got this right, I think this is what you said, we're justified in doing something, but we would be wronging those against whom we fight, okay? I have a question about this. Wouldn't those against whom we fight become liable to our fighting against them if they're defending something that that justified thing we are trying to vindicate? Okay, so wouldn't they then become liable at that point? Or would we become liable to their counterattack if we are wronging them, right, by attacking when we're only justified and not just? Does that make sense? I mean, I'm trying to like figure out what the distinction, because it's a distinction that I think, in fact, that from the kind of just war theory that Professor Johnson was advocating, that I don't know we would want to make. But anyway, so if you could speak to both of those, I appreciate it. Thank you.
Sure. The use of force. The international institutions are pretty woeful. Also, I don't see how to get to better ones, even if I were totally convinced that it would be a good thing if we did. The sort of proposal that David makes, it's good to have proposals like this out there. But surely there have been a lot of these proposals. I was thinking of Dick Falk and Saul Mendelevitz's World Order Models Project. And, in the multiple thick volumes that project produced of how you could do this and this and this and this in various sectors of the world to build up a more robust international regime. Well, what's been done? I don't know. And indeed, where we do have the institutionalization of our more international, where we do have more international institutionalization, such as, for example, the ICC, I think that there are some very real problems with this. So again, I'm just not sure it's a good thing. So that's fundamentally my view of that, and that's one of the things that throws me back on the importance of robust, well-constituted states that are committed to a responsible version of justice. I've been working through the parts of Augustine's City of God recently with a seminar, and the function is really to read this very closely and see what Augustine was trying to say. And it's just really striking in there how he goes back and forth from chapter to chapter, talking about Rome. One chapter he's talking about how all the defects of Rome vis-a-vis the city of God. And then in another chapter he's talking about how Rome has really been a bad actor vis-a-vis other societies, conquering them and so forth. And then a few pages later, he's talking about all the goods that Roman society brought to those people that it conquered. Politics is a messy thing, and we may not be able to get beyond a well-constituted state that would be, in some sense, a model of the best that the city of Earth can be.
Let's join me in thanking these panelists for a great panel. I believe we're over time.
I want to add my thanks to Joe for pinch hitting again at the last moment. And just so everyone knows, the panelists receive a book from another philosopher who happened to also be an operational artist and also a POW at one time for 7.5 years in Hanoi, Admiral Jim Stockdale, one of his books. So each panelist is getting presented that book. Admiral Stockdale received the Medal of Honor for his leadership, but attributed a lot of his success to his study at Stanford in the areas of ethics and philosophy. And so a lot of what we talk about becomes important for the practitioner as well as we sort through what this all means out on the battlefield. So again, thank you, gentlemen, for your contributions. And Lieutenant Commander Rack will give you your presence. And we're going to reconvene at 3:30 p.m. For the final panel of the day. So a break until then.
It's almost never the case that we allow the deliberate killing of other people, even for incredibly overriding goods. So, within domestic jurisdiction, there's a famous case of Dudley versus Stevens where 2 sailors killed and ate a shipboy. They were shipwrecked on it. They believed reasonably that if they didn't kill the cabin boy, they would all die, and they were not acquitted. And I think there's a strong intuition that that's right. That things like the right to life, right against torture, some other very, very core rights like that are never or almost never vulnerable to that kind of lesser evil justification. But just very quickly on the cultural extermination question, I actually also think the other side of that is that it's incredibly difficult to do, right, through the course of military occupation. If you think, for example, about the cases of Germany and Japan, okay, occupied at the end of the Second World War, their political structure is completely dismantled, replaced by alien ones. 65 years later, they are still recognizably the same culture of Germany and Japan. The Eastern European states that were, again, subject to decades of very, very brutal domination by the Soviet Union. Again, these cultures are incredibly resilient. So it's when we think about cultural goods in the context of war, we should remember that it's not such an easy thing to exterminate a culture in that way.
Sure,
Maybe McDonald's. And
Sure,
I would do that, but
I'd love to take a swing at these guys again, but I will open it up to other people, please. Yes, sir.
Just a request for clarification on an issue that both you seem to agree with. That is where you start from, that actually force is justified only against somebody who has made himself liable to be attacked. I both agree on that. Jeff even mentioned the words more culpable. Maybe I'm misinterpreting it, but that doesn't seem to be right. I mean, there are many situations where somebody is liable to be attacked, even though the person is not morally culpable anyway, right? For example, your colleague at Oxford, John Gardner, has done wonderful work with the law of torts, totally unrelated to this, on outcome responsibility. There are certain things outcomes that people cause, like the enemy soldiers, for example, when they fire. I mean, even if they, on your own account, David, the soldier is not responsible, as you argue in your book, that only the elite. This soldier is actually liable to be attacked by me. And I don't care if he's culpable or not, actually, on pure outcome agency grounds. I guess,
I would just say, David and I agree with you, actually.
Okay,
And we don't think that culpability is a necessary condition of liability to defensive action. And okay, yeah, and I do think that the notion of outcome responsibility, something like that, probably got to play some role in the kind of view that David and I have.
Professor Elstein?
Thank you. First of all, I want to say to Jim Johnson, just to thank you, Jim, for reminding us of the historic record. I think that's rather helpful, and it does raise some interesting questions about how strongly we believe that historic record has bearing on how we think about the issues today. And that gets me directly to concerns that are starting to surface from listening, David, to you and to you, Jeff. And that has to do with something like the following. The just war tradition, as I understand it, has been about a political good, the issue of justice, comparative justice, not justice in some absolute sense. The just war tradition is not about morality in some abstract or absolute sense, but about forms of practical morality in the world of statecraft. So that said, we then immediately, it seems to me, get to the issue of the status of political bodies of a certain kind. Human beings are never in the world just as a bunch of isolated individuals. We're always in the world organized into bodies of some sort. And the bodies that help to define us are multiple, because we're members of not just one community but many. But finally, there's a political community that we're part of that I would say is not reducible to its individual parts. That is, it has a standing and a power that we lose if we think that we can just sort of dissolve it and see the individual bits that, in a sense, make it up. And it strikes me that the direction your arguments go tend to sort of dissolve the question of the political body in favor of an emphasis on each individual or each person. Clearly, it's absolutely vital to pay attention to, I talked about the dignity of persons, equal moral regard for persons, but at the same time, you know, we need political bodies of some sort to recognize and to protect those rights. So we can't do it all by ourselves. So that, I think, does really get us to one conundrum here, which has to do our responsibility simply by being citizens of a political body for whatever actions are taken in our name, taken by the sovereign, if you will. Now, one of the things that I think is happening at the moment, and Jeff, I don't know if you'll agree, or Jim, I don't know if you'll agree, has to do with perhaps, although it's not been named this way quite so much, something of a resurrection of the notion of sovereignty as responsibility as the medievals understood it. It's not just about control of a territory, but that legitimacy hinges on, something in addition. How we think about sovereign authority has to do with some kind of responsibility. If so, that would be a good thing, it seems to me, but it still means that we do have to think about these political bodies and not just about individuals. So what I don't see in either of your presentations is a real consideration of these political bodies that we call states or polities and so on, and how we are, as citizens, in a sense, implicated in them, no matter what we do in some particular way. I also want to raise the question of, in the issue of just cause, assuming, if we can, that we have a situation, there's a clear-cut case of just cause and unjust cause. Let's assume that. It's often murkier in the real world, as you know. Who finally is making those judgments? If you've got two parties, each of whom is claiming justice, it strikes me that there is something that you each are assuming that you weren't saying, which is that there's some way to adjudicate between them and to say justice lies on this side here, and then certain things follow for you that would not follow for me automatically about the status of combatants and so on. So that's just one of the number of issues I would want to put out there for your consideration.
Yeah, I have something to say about that. What I think is most important to say about states, in my view, which is a kind of anti-statist view, at least with respect. I like states for what they do domestically, and I kind of don't like them what they do to other people.
I'm not sure you can have one without the other.
Well, they do tend, they do tend.
to involve the common good, did they not? Assessments of the common good.
They do tend to go together, but here's what I want to suggest, that people can together create relations among themselves that can alter their own rights and responsibilities and obligations. It can create new permissions for people who didn't already have them. They can create new rights for people who didn't have them before.
You mean domestic politics?
Among themselves, yes. People among themselves. So make this a state if you'd like. But relations established among people themselves can't actually ever extend what it's permissible for those people to do to people who are not part of that group. That is, you and I can't get together with our antecedent pre-existing permissions with respect to what we can do to others and somehow together manage miraculously to extend those permissions so that we can, by cooperating together, make it more permissible, make it for us permissible to do more harm to other people than it would have been for us to do on our own. And that's very relevant in the case of war. A lot of people think that when people form themselves together in a state, and the state has these responsibilities to citizens and vice versa, that can give members of that state enhanced permissions to cause harm to people outside of the state, permissions that they wouldn't have had independently of their interrelations within the state. That's what I think is false. And I think theoretically and practically that's a very important claim. If it may be wrong, but that's what I would defend.
Yeah, I would want to argue against. I won't do it now, obviously, but I think that's a position I'd want to argue against on a number of grounds, but we can't have a private conversation about it. So.
Okay. We have other hands. I have a gentleman here, then Professor Waltzer and Henrik. Yeah.
Jim, this may involve you in elaborating some of the things Gene was just saying, but it does seem to me that since David and Jeff, I emphasize human rights so much, and that's a part of your paper you put to the side. It might be useful for you to make some comments about the role of human rights.
That was a question for Professor Johnson to say something about the role of human rights. Just so everybody can hear that, I don't think everybody heard that across the room. And please do try to speak up as loudly as you can.
Well, I was thinking as Gene mentioned R2P, that basically what I said in my presentation was that what happened with Grotius and Westphalia threw the baby out with the bath. They were trying to avoid the possibility of the kinds of justifications for resort to armed force that had produced the 30 Years' War. And among those, especially in the first part of that 30-year period, were religious claims. We're right, you're wrong, you know, we have the right to use force to coerce you to be like us. And it succeeded at that. This redefinition of the whole idea of sovereignty, this redefinition of the right to go to war that effectively removed the possibility of moral judgments, succeeded in doing away with religious warfare. However, it opened the door to some not so good things. One of the more immediate results was the development of the idea of liberum jus ad bellum, that is, that the sovereign has the right to decide when he wants to go to war. The ruler has the right to decide when he wants to go to war to protect the sovereignty of the society that he or she governs, and to serve it, to increase its domains, and so on. And that, thank goodness, eventually died away, but not until after more or less a century of the so-called sovereigns' wars. So then we end up in the 20th century with tyrants that are sometimes they're kleptocrats, sometimes they are people that are wantonly abusing some segment of their population because they're of a different tribe or a different ethnicity or a different religion or whatever. You know, all kinds of reasons for this. And R2P is really a response to this. And I think it's a very good response to this. It does seem to me that the international order and individual states have obligations to, or have an interest in, let me put it that way, an interest in maintaining the moral responsibility of people with the responsibility of government to serve the good of the people over whom they are set. I am, in my own writing, I have not emphasized the conception of human rights enormously, because I really begin at the other end of the thing. But I would grant that when you turn the telescope around, the question can be put in terms of the rights of groups, the rights of individuals, the rights of collectives that are larger than groups, and we can think of these in terms of universal human rights. But one thing that has always given me pause is the inability, even of the people most dedicated to pushing this idea, to agree on what those rights are. If you look at the various UN-sponsored human rights conferences and the resolutions they have produced, sometimes the rights that are claimed by one set of resolution are in tension with or contradictory to the rights that have been proclaimed by another. And even when you get something like the U.S. Catholic Bishops' 1993 statement on the whole issue of use of armed force, in their discussion of intervention, all they can finally agree on is that it's important to intervene to protect egregious violation of basic human rights. Well, great, that's good, but where can we say what these basic human rights are? Can we say what their sources are? Can we say who really has the responsibility to protect them? And what to what extent those responsibilities extend. And I don't think that there's really anything like the kind of consensus we need to build a whole edifice of justification for use of armed force on that basis.
Professor Walter?
I have first an observation and then a question. Gary Bass has written a very good book and a very big book about humanitarian interventions in the 19th century, of which there were a considerable number and a great deal of argument about for and against these interventions, and human rights figures not at all in the argument. So it does seem to me that this is our way of justifying what may be necessary moral actions, but there are other ways. And there have been other ways, and there will be other ways. Now, my question is addressed to David and Jeff, but I'd like Jim's comment also. It seems to me that the deep purpose of your critique of just war theory, and I think David said this at the end of his talk, is the transformation of war into crime on the one hand and police action on the other. That was the intent of the UN Charter, and it led to the falsely described Korean event as the Korean War, as it was, but the UN insisted that this was a police action against a crime. But if that's your intention, doesn't it depend on the creation of international institutions radically different from the ones that we now have?
Gentlemen, yes.
Yeah. So first of all, on human rights, I mean, I think, Michael, you're absolutely right that there, in many ways, the modern doctrine of human rights articulates or restates ideas that can be stated in other terms than human rights probably have in the past been restated in other terms and probably in the future will be as well. I think that's actually a source of strength rather than a problem. And just to come to kind of Jim's challenge, what's the consensus? You're absolutely right to say that there's no consensus on what the whole package is, and there's a great deal of dissensus around the margins. It's clear that a lot of the rights that you find within the UN Charter, for example, are largely aspirational. They're kind of things that we think would be nice to have, but they have a very, very different status to what I think of as the core element of basic negative rights. So in answer to kind of your question, where's the consensus about what are the rights that can ground intervention? I would say, well, they're the core negative rights, such as the right to life, the right not to be killed or attacked, the right to be free from rape and sexual abuse, the right to be free from torture, the right to basic liberty and property security. And maybe one or two others. And there may be others that kind of fit within that, but it seems to me that we can get a really considerable amount of consensus on the fundamental importance of at least that package of negative rights, and that when those rights are violated on a systematic basis, that is grounds for that's certainly potentially grounds for violent action. I mean, just to come to Michael's point, does this envisage different institutions to what we have at the moment? Almost certainly, yes. But I think that as well can be a source in terms of thinking about how to develop those institutions. So to give one example, the conference is on 10 years from 9/11. Now, at that time and shortly after, many people, myself included, said or believed that our primary response to these terrorist atrocities should have been more of a law enforcement activity than a military response. Now, one of the problems, of course, is that our capacity for effective transnational, international policing operations to hunt down and bring to justice organized criminals like Al-Qaeda and their ilk are very, very weak. But since then, we've spent somewhere in the order of, I can't remember what the figure is, but it's several trillions of dollars prosecuting these wars. Now, for comparison, the operating budget of Interpol is somewhere in the region of about $30 or $40 million a year. Now, what mightn't we have been able to achieve by diverting a small fraction of the budget we spend on these military operations towards developing some kind of capacity that was perhaps regional in focus, perhaps under the mandate of NATO, but whose training, whose weapons in operation, whose ROE was some kind of a composite between that we have for domestic police forces and those that we have as military. I don't know the answer to that question, but that seems to me to be a useful kind of practical possibility that we might want to explore.
Jeff, real quick.
Yes. Michael speaks of the transformation of war into crime and police action. My view is that morally, it already is that. There's no transformation needed. Legally and politically, of course, if we want to bring morality and law into greater congruence, then yes, we need to try to transform war into something more like the model of police action. In law, we do have these two distinct sets of norms, the norms governing police action and the norms governing war. And those norms do serve different purposes. They're quite different. And as of now, the norms for police action, I think, couldn't be applied to war. We have to have the norms, the legal norms governing war that we have now. But the answer to the question is yes. If we want to make war legally more like police action, as I think it is in its moral nature, then we can't do that without the transformation of legal and political institutions. And I've just mentioned that I have a long paper describing such a possible institution, an institution whose task would be to try to provide reliable and authoritative guidance in discriminating just from unjust wars in order to guide the consciences of individual combatants. Have this paper forthcoming in a book dedicated to Michael Walzer. The book is called Reading Walzer. So you'll...
I'm supposed to write an answer.
Okay. So you already, you probably know this piece anyway, but that's my effort at one suggestion for how to try to transform institutions to make the right moral norms more directly applicable to war. And the vision of war, by reference to the moral standards that David and I have been defending, is one that is intended to provide guidance for the shaping of new institutions if anybody's willing to take it seriously.
Michael, I agree with you that the institutions, the international institutions, are wanting. One of the reasons that I have been very, very firmly against arguments of others that any resort to force ought always to have a UN mandate is that you're not going to get it in practice in times when it's absolutely necessary to get it. Kosovo, for example. And B, if you're thinking of actually having forces under UN direction, then the history does not suggest that the prospects are very good. And if you start looking at the institutional structure of the United Nations, it looks even worse because there's really no command and control authority. There's no armed force. Indeed, you depend on the individual states with their particular interests, their particular political baggage, and their often very differently constituted militaries to do what needs to be done. And so in terms of just thinking about the use of force, the international institutions are pretty woeful. Also, I don't see how to get to better ones, even if I were totally convinced that it would be a good thing if we did. The sort of proposal that David makes, it's good to have proposals like this out there. But surely there have been a lot of these proposals. I was thinking of Dick Falk and Saul Mendelowitz's World Order Models Project. And, in the multiple thick volumes that project produced, of how you could do this and this and this and this in various sectors of the world to build up a more robust international regime. Well, you know, what's been done? I don't know. And indeed, where we do have the institutionalization of our more international, where we do have more international institutionalization, such as, for example, the ICC, I think that there are some very real problems with this. So again, I'm just not sure it's a good thing. So that's fundamentally my view of that, and that's one of the things that throws me back on the importance of robust, well-constituted states that are committed to a responsible version of justice. I've been working through the parts of Augustine's City of God recently with a seminar, and the function is really to read this very closely and see what Augustine was trying to say. And it's just really striking in there how he goes back and forth from chapter to chapter, talking about Rome. One chapter he's talking about how all the defects of Rome vis-a-vis the city of God. And then in another chapter he's talking about how Rome has really been a bad actor vis-a-vis other societies, conquering them and so forth. And then a few pages later, he's talking about all the goods that Roman society brought to those people that it conquered. Politics is a messy thing, and we may not be able to get beyond a well-constituted state that would be, in some sense, a model of the best that the city of Earth can be.
Let's join me in thanking these panelists for a great panel. I believe we're over time.
I want to add my thanks to Joe for pinch hitting again at the last moment. And just so everyone knows, the panelists receive a book from another philosopher who happened to also be an operational artist and also a POW at one time for 7.5 years in Hanoi, Admiral Jim Stockdale, one of his books. So each panelist is getting presented that book. Admiral Stockdale received the Medal of Honor for his leadership, but attributed a lot of his success to his study at Stanford in the areas of ethics and philosophy. And so a lot of what we talk about becomes important for the practitioner as well as we sort through what this all means out on the battlefield. So again, thank you, gentlemen, for your contributions. And Lieutenant Commander Rack will give you your presence. And we're going to reconvene at 3:30 p.m. For the final panel of the day. So a break until then.